are doing well. I wanted to bring you some information on how you can stop eviction collections. We went over for this credit kickoff how to deal with different types of credit issues. And one of the issues that people are dealing with when it comes down to collections is collections for evictions. Now, collections in itself is there's various types of collections. We talked about consumer collections. Then we also talked about medical collections, how to deal with medical collections, and tonight dealing with eviction collections. So when you're dealing with collections, it's about the same principle. Usually what happens is the original creditor could not collect on a debt within 180 days. So what they will in turn do is write that off or charge it off on their they'll charge it off on their taxes and get a tax credit, and they can no longer try to pursue that debt themselves personally, a lot of times without getting into issues with the IRS. So what happens if you owe them $2,000, they write it off, the $2,000 as a write-off, then what happens is they will simply cannot come back for you for that $2,000, because if they come back to you for that $2,000, then they got paid $4,000, the $2,000 tax credit, and collecting the $2,000 from you. So what they will in turn do is turn around and they will sell that debt. So when you're dealing with collections with a third party at any time, they have to prove they have a legal right to collect on that debt. So many a times they'll say they purchased the debt. Anything that you purchase, you need to show a receipt. You have to show proof. Then on top of purchasing something, so if you purchased, let's say some tools on the street or some jewelry from somebody on the street that don't have a store, and this could totally be stolen, and you purchase it, because you bought it doesn't mean that you're the legal owner of that debt. It's the same thing even with these debts. Because they purchased it, it does not mean that they're a legal owner of that debt, because there's many times that these debts will change hands and it's information. So another debt collector could actually steal your information from the prior debt collector and never paid for that debt. So it's like a chain of title. So you'll see these debts sold constantly. So you need to ask for proof of the chain of title. So it's just like with a home. You will have a home. If you're buying a home, it's called a title search, because you pay for that home, because you purchased that home even from a legal family member of a person that owns that house, don't mean that they had a real legal right to even sell that house. So you need to find out with these debts, was the chain of title correct? So with any third party debt. Thank you so much for joining me, Kenneth. I really appreciate it. Anybody too, as y'all come in, do me a favor and just give a like to help the algorithm to get that notification out. So when you have collection debts involving a eviction, it's even more complicated. And here's why. I myself am a landlord. So when you have tenants, you have a lease. Not only do you have a lease, each state is what you call have landlord tenant laws. So landlord tenant laws are different from regular civil court lawsuits, small claims court lawsuits. When a landlord take you to court, we are taking you to landlord tenant court. because there are special rules governing those types of contracts. And we have to go for the possession. That means I own my buildings, I own my properties, but I do not own or have a right to the inner leased out portion of that unit. I have to go back to get possession of that unit. That has nothing to do with money. That has nothing to do in my state of New Jersey to get monetary compensation for the rent that I'm on. I am just strictly, when you take them to landlord tenant court, just trying to be able to have access to that unit once again. And that's when a constable or a sheriff, it depends on your state. And when I had a house in Connecticut, my 3-family, it was the sheriff. In New Jersey, it is a court officer that comes out to do the lockout portion of that. So what happens is a landlord then, after that person's out, or many times even if that person is there, once you get possession or the judgment in court, you would have to take a whole nother action. That is how it works in my state of New Jersey. Now, different states may be different, but even when my property in Connecticut, it was same thing. You have to sue that person for the monetary part of the back rent or damages they caused that is owed to them. So this is where it gets very interesting. When you have a collection from a third party collector, did they follow the state guidelines, the landlord tenant guidelines of that state? Remember, they are not your original landlord. So number one, generally that landlord or that building have written that debt off as a loss on their taxes. Okay, so that's number one. If they or someone like me, a normal landlord, they usually have to pursue that debt. Now, for me to sell that debt to a outside company, you would have had to agree with that in your lease. So number one, you need to read your lease. Many of these companies, when you send what's called a debt validation letter. Now, I have a different debt validation letter when it comes down to evictions because it's a whole different standard. The regular debt validation letter will normally ask them for their legal right, the original contract. But when you're dealing with landlord tenant laws or anything that has to do with rentals, you put down a security deposit. And there are special laws in that landlord tenant that what should have been done with that security deposit. And furthermore, if you moved out early, if the apartment was rented, what did they do with the security deposit? Was that security deposit, if they're saying damages took place, was that applied to those damages? And how much was left over? Many states require a landlord to send you in a certain amount of time, whether it be 30 days, 60 days, they need to tell you how they apply that security deposit. Now, one caveat is when you moved, did you forward your mail? Did you leave them an address? Many tenants will because they're expecting the return of their security deposit. But did that landlord give you a breakdown on the damages, how much back rent? So with this third party company charging you or saying that you owe them a debt, do they have that details? What do I owe you for? If you're saying that I owe $7,000, what is that $7,000 for and why do I owe it to you? Number one, What did you guys do with my security deposit? Number two, was my security deposit handled properly? Different states have different rules on what they have to do with your security deposit. Put it in a bank account. Did they, with that security deposit, did they apply it right? Did they notify you on what way? It's many times, even if you broke your lease on a lease, a year lease, many states only allow that landlord to charge you until you rent that apartment. So say if you broke your lease early, you had 12 months on that lease, but you moved out 10 months, and you had 2 months left. If that landlord in many states rent that apartment the next month, they cannot charge you for those other 2 months. So you need to demand from that third-party collector what happened with the application, or what are you charging me for? What months are you charging me for? Are you charging me, and give me a breakdown, a detail on, are you charging me for a month and a half rent? Are you charging me for damages? And if it is damages, what damages are there? Where's the proof of these damages? If they're saying certain damages was done, some damages are just wear and tear that have absolutely nothing to do with you. So take, for instance, if you have a damage like a leak under your sink, a lot of times in that case, if it's a leak of a faucet, you most likely did not cause that damage. That's just something through regular wear and tear, versus somebody having a child a lot of times clog a toilet. Now that may be in your lease where you're responsible for certain items like that. But if it is just normal wear and tear, it's many a times for those damages that you cannot even be held responsible. So you need to challenge that third party collector who usually don't have that information. I have a client now, they got in contact with the building that sold the debt, and they don't even have that information, because a lot of these collection debts come up possibly years later. But the damage that they're causing you, you're not able to get an apartment, you're not able to get a job, vehicles, and especially when it comes down to housing. Apartment, you can't get another apartment, you can't even purchase a home with these kind of debts. So this is what you need to challenge that third party for. You need to, number one, ask them for your original lease. You need to read that lease, because many a times when you ask them for the original contract, all they're going to do is send you the bottom of the lease with your signature and the landlord's signature. But that doesn't constitute them having a legal right to collect on that. That does not constitute that. It has to say somewhere in that lease that you're surrendering your right to allow them to sell that debt. So you need to read that contract for that. Number two, you need to break down and ask them, what are they charging you for? What are you charging me for? Number three, you need to find out what happened to your security deposit. Find out from them, how did y'all apply my security deposit? Where did my security deposit go to? What did it pay for? Number four, you really need to look into your landlord tenant laws to see how that security deposit should have been handled. You need to find out what should have been done with it, and you can request the accounting of show me some accounting for that security deposit. So these are the ways that you can pin them down. Now, say they cannot produce this, they don't have the information or all that they send back. Many a times, all they're going to send back is that signature line of that lease. If they continue to report that, what you can do is what I always state. That is causing you damages, personal financial damages. And you need to find out who is the officers, the board members of that company. You can find that through the Better Business Bureau. You can also find that information a lot of times at that State Department of Treasury, sometimes the State Department of Taxation, because a lot of times they have to file that the articles of incorporation naming those people. You can also, if it's a big corporation, simply go to LinkedIn and see if you can find anybody that works there. Now, the second part I'm going to tell you does not constitute legal advice. This is for educational purposes only. I am not an attorney. But what I can tell you, what you need to do, furthermore, when you get a breakdown of those charges, you need to see if they're charging you late fees. Because late fees can constitute a large part of that bill. Late fees should be included in your lease. If the lease does not allow for you to have late fees, they cannot charge you. And with all this information that you have, that they are reporting either not 100% correctly, or they can't produce this information at all, this is what is called defamation of your character. Defamation of your character is defaming who you are as a person. And why does that matter? It matters because the next landlord won't rent to you because what they are reporting about you on your credit report. So with that, you have a right to sue them for defamation of character. Let me tell you how you're lying on me. I don't care if they're reporting that information and it is not, say it is true, but if it ain't accurate, I'm going to sue you because you're lying on me. The prior landlord or my next landlord, if I only owed you $100, but you're telling them I owe them $2,000, you're lying on me. That person may still rent to me if it only appears that it's $100 collection. But if you're running around telling everybody I owe you $2,000 and making me look like I'm a bad tenant for information that's not even true, and besides the fact I never rented from you, I don't even know you, and I don't know who your company is, you're lying on me. And so what you can simply do, and I'll use this as an example, leveraging the small claims court process in order to clean your credit up. So many times people will keep saying, oh, you disputed. Well, your right to dispute is coming from the Fair Credit Reporting Act. That is a federal law instated by Congress and House, your congressional members that put that in law. But the judicial system is what enforces laws on any level. So if they are violating the Fair Credit Reporting Act, many people, oh, well, you can go to federal court. Yeah, but have you ever heard the term, don't make a federal case out of it? Because going to federal court could be quite lengthy and quite expensive. But going to your local civil court, small claims, the process happens much quicker. Then I don't care if they're in another state, in Georgia, Alabama, whatever, a different state than what you reside in, those companies have to operate by the same laws that govern your state. Okay, so I don't care if they're based in Mississippi, they are doing business in New Jersey, so they have to follow New Jersey laws. Furthermore, are they even licensed to conduct business in New Jersey? They might be licensed in Mississippi, but they might not have a license in New Jersey. So are y'all compliant to New Jersey laws. So what you need to do is file a small claims court lawsuit naming those employees plus the company. And the reason why you're naming the employees, a company is a entity that doesn't die. It has its own social security number or EIN number, which is like a social security number, so it can live on. But it does not make its own decisions because it is really a corporation on paper. There are people that are making these decisions. There are board members. There are managers. So any injury that you have from that corporation, you can hold them personally responsible. So you will simply name them personally in the lawsuit. And what that gives you is what you don't have currently, and that is leverage. The problem is what's going on with these companies, these collection companies, they have leverage given to them by the major credit bureaus. I say it all the time. The major credit bureaus is no different than McDonald's. They put the name bureaus like they're a federal system, but they're not. They're private corporations. Better yet, they are private corporations that through lobbying and through big donations are allowed to oppress the rest of our lives. All they're in the business of is selling your data and that's how they make billions of dollars. And why they have the right to even sell your information without your consent? Because in the law, they have a right to. There are certain data providers that you can put a freeze on your information. But the major credit bureaus, they are allowed to sell your information. But the Fair Credit Reporting Act, which is legislated, give them parameters on how they're supposed to do this. But like I said, you would have to take that on a federal level, and that's a lot of times really hard to fight those big corporations. So what you're doing by taking the collection companies and those that manage them to small claims court is attacking the source of the information. And what would happen, what has been my experience, when you name them personally, when you start taking names, kicking butt and taking names, guess what? Now, Betty Sue, John Jacob Jingerheiner Smith, that runs the company, is not hiding behind ABC Collections. No, I'm talking to you. And what that means is just like they're putting a judgment against you or pursuing negative information against you, if you win that case, if they don't show up, if they don't answer, you're going to have a judgment against them personally. And it's going to hit their credit report. And they know that. And what was going to happen, that's going to give them incentive to take that off your credit. That's what it's going to do. It's going to give them incentive to delete all that within 30 days. And that's what you asking for. Listen, this is how it's going to go. Like I tell people, if you on the street, you walking down a dark alley and somebody put a gun on you and say, hey, give me all your money. You know what? You're in a position, you got to give them all your money. But if you are toting, guess what? And you pull out yours, negotiations is totally different. Then that criminal will kindly say, if you say you'll back up, I'll back up. It don't have to be like that. It's the same thing with them. Then you have leverage. So what you're trying to do is create leverage. So if they saying, for instance, I owe them $500. Oh, I'm suing you, babe, $50. I owe you, you owe me more. And the grounds is defamation of character. You are lying on me. I don't know you. I never did business with this company. And they have to come and show proof. Now, many of them, don't let them scare you. They say, hey, I could show you the bill of sale. I don't care what you're showing me. You got to show me my legal consent to that original creditor to sell that debt. Where did I tell my landlord that they have a right to sell that debt? Because we all owe debts. Right now, you owe some kind of debt, whether it be a student loan debt or whatever. I just can't knock to your door and say, pay me your student loan payment. Here's this piece of paper. You have to give consent when you are making this agreement with the original creditor that you're going to give them the right to sell that. Many a times that happen with your mortgage. Many a times that might happen with the vehicle, because people are signing things that they're not looking at. But this, with your landlord, you have to see if you gave that right for them to sell that debt. Even if that is in there, if whatever they're reporting and saying that you owe is not 100% accurate, they're lying. So that's what you're going to have to do. So you need to simply hit them with a small claims court lawsuit, naming these employees, and then you could have leverage to negotiate. Usually what I do in these cases, call them up. They'll either have their attorney to contact them, ask them what would it take to settle the debt, and what would settle the debt will be simply for you to remove this within 30 days, and I might get $200 for them to pay for my court costs. They will simply send you a release form that you need to read. And what I will say, to be clear for you guys, you need to say all credit reporting agencies. So not just the 3 major credit bureaus, that mean LexisNexis, CoreLogic, any of them that can name that's working in the background, I want it off. Okay, I want to delete it. And usually what would happen, they might email that over to you. They might send that over to you. You need to read that thoroughly. It wouldn't hurt. And it's always best for you to talk to an attorney. And if you have access, if you need access to an attorney, I'll be talking about lawsuits and way to leverage to have access to attorneys for pennies on a dollar, even if you're being sued, to overlook your paperwork and to help you, guide you with the laws in your state. So if you have access to a legal service, you send it over to your attorney, have them to look at it, and then you sign it, and then they should cut you your check. Sometimes they send it over via FedEx. That's how I usually get mine. And then you cash it, and they usually remove it. And if they don't remove it, you already have your proof to send to the bureaus on them to delete that. So hopefully with that surmise for you guys how to attack your eviction collections. One other note with eviction collections, make sure you just read that thoroughly. Now, this will not take care of if you actually got a judgment or if you actually was evicted. What happens with that, which is why you should not try to get eviction. Any eviction actions a lot of times will go into that court system. So in New Jersey, it's New Jersey courts, and that will not be removed. You will have to see the courts about removing that. Okay, so a lot of times those actions will show up. If a landlord do a pull or use a service because the action was filed in court, and a lot of these background checks will see if it's any actions that ever been taken against you. Even if you don't get fully put out or evicted, because the action is there, it can prevent you from getting an apartment moving forward. So I hope that is clarity for you guys on that subject. And I saw some questions come through, and I see Mr. Walker said, facts, facts, facts. Thank you so much. Boss News said, how I love how you teach. Thank you. I really appreciate you tuning in with me. Miss Smith is said, is it okay to settle with them if you agree to pay small portions of the debt? Miss Smith, if it's a third party collector, you got to be careful, because what happens if you never seen my information before, third parties usually don't have a legal right to collect on a debt. So what they do is record your conversation. They're already in knowledge that they don't have a right to collect on that debt. So how they rope you in to agree with that, many a times they'll say this debt is for this company and they bought it. So what happens is they know they don't have a connection for that debt to collect, because you never did business with them. You never got an Uber ride. You never got a sandwich. You never got any food, anything from these people, a t-shirt. So they know to make that connection legally is not there. So when you get on the phone, they record this conversation. And what you begin to do, if you agree to start paying them, then you're making a verbal contract. So you want to be careful with that. And a lot of you guys, even in your own state, you want to make sure you're careful even with these collections, because you can reactivate statute of limitations. It could be a time frame that each one of these states that they can no longer sue you. But if you start making agreements to pay these people and they record it, you can now open yourself up to a lawsuit that you never had before. So if you did do that, then, you know, it is what it is. But I don't suggest people doing that with third parties. Now, if it's the original creditor, okay. If it's your original landlord or building, that's possible to make that debt go away. But I don't really do I advocate for you to pay a third party. That's me. I understand if people are closing on a home, and a lot of time these kind of debts will pop up because the credit bureaus, when you're looking for a home, will sell what's called a trigger list. They put it out that you're looking for a home. This is how much crookedness, how much dirty underhandedness that's in the system. So this is why when you hear me talk about the credit bureaus, I tell y'all credit is going to handcuffs. I don't pom-pom the credit system whatsoever. I just let you know how the matrix is working, because what it does, it is a matrix. It feeds off of you. You give it life, but they are allowed to do that. And then they sell that information, and you'll see an old collection for an apartment pop up, or you'll see all types of collections pop up. And it happened to me because they know you cannot close on that home with these open collections. So many a times people might pay it at that point because you really have no other choice. It's a trap. But besides that, I can't, and I'm quite sure it's outliers for every situation, and I have done it because they did this to me when I bought my first home. Just popped it the day out before my closing, and they just really did me dirty. They did me dirty on that one, but they got it. So I had two of them hit me up. But you got to be careful too, because they'll drop your credit score as soon as you pay them. So normally I don't advocate making deals with them, and I don't advocate you paying them, especially without sending the debt validation letter to even prove that you owe them. So hopefully that was helpful. What do you do if you got a notice in the mail you were being sued, but the court date has already passed and the company got a judgment? I never got a chance to go to court. Okay, Scott, what you should do, number one, always speak to an attorney. But if you did not, this does not constitute legal advice. So I just wanted, this is for educational purpose only. So number one, you need to talk to an attorney in your state. You need to find out how much is that judgment for, because different states Like the state of New Jersey, we have special civil and civil court. So special civil, which is small claims court, is anything under $15,000 is considered small claims court. But anything above that is civil court, and the process is much longer. You need to find out how much that debt is, that they got the judgment, and you need to tell that to an attorney, and you need to find out, even if you just ask an attorney, how to overturn a default judgment. Now, in my state of New Jersey, and I'm using that for educational purposes only, you can use this example to search this out in your state. What you would have to do is usually file a motion. Motions in my state, and normally I'm going to go out on a limb and say most states are free, because the answer is free, the person that initiate the lawsuit. But it could be that you had to, because I think in Alabama we had to file. So it could be possible, but that was Alabama. I had a situation in Alabama. I had a situation in Alabama, Lord Jesus. And they had some stuff going on there. But usually with a motion, you don't have to file, but you pay a fee. But you could, because in Alabama, we did have to pay a fee. But you would have to file a motion to overturn a default judgment. Now, you need to talk to an attorney, because what a default judgment mean that it wasn't judicial. Usually when you get have a court, what makes it judicial is heard, witnesses, and recorded. So usually a default judgment, you need to explain either why the court wants you to know why you ain't come to court. That's what they said. Never mind whether you owe this, you disregarded the court. So you need to have usually set reasons to overturn that default judgment. So whether they sent it to a wrong address, I will say a lot of debt collectors will do that on purpose. They will send it to an old address. They'll send it somewhere else. But you need to, number one, find out, where did they serve that? Was the service correct? So depending on your state, whether it was special civil or civil court, they have to serve it a certain way. So in my state of New Jersey, special civil, which is small claims under $15,000, they can send it to you certified mail from the court. If the post office do not return that as undeliverable, they will say that that was a good service. But in my state, you can prove if they didn't serve you in the right jurisdiction, county, that was improper service. So you need to let the court know, the reason why I didn't show up, and you need to attach proofs. I didn't show up because I don't live there. Now, if it was over in my state, $15,000, that's civil, they actually have to have a process servicer or a constable come out and serve you. So find out, number one, did they serve you properly? That can be a reason to have that overturned. So you need to find that out. Now, if they're supposed to have a servicer, sometimes they will serve it. These people get slick. They'll serve it to a relative. But if that relative maybe was not in their right mind, if they're an elderly person, if they served it to someone who was a child that came to the door, many a times, many states, I think my state, the person have to be about 14 years old in order to receive a proper service, to receive that for you. You need to find out, did they serve you properly? Find out if they served you at the right address. And if you were, because of the COVID, if you were sick, if it was other reasons why you could not show up or you did not get it, that's what you need to have your evidence and then state that. But like I said, you need to talk to an attorney, and usually it would be a motion to overturn the default judgment. And what would happen is It doesn't mean that lawsuit will go away, but what it means is then it will have to start, you have to file sometimes an answer to the complaint. So that answer, and I'm just giving general, an answer to the complaint means an answer to the summons, to what they are accusing you for. If they're suing you for back rents, either you need to say, no, I don't owe that back rent, and I'm suing them for defamation of character, and I'm naming this one and this one because that's not true. So you can always countersue. Now, sometimes with that countersue, if you overturn that default judgment, it may be fees involved, but it's worth your while to countersue always. When in doubt, countersue out. That's mine. That's my advice. When in doubt, countersue out. I'm shooting my way out of Dodge. So you sue me because of child buy. I've been sued and I sue back. You sue me, I'm suing you back. I'm like a child. When it sue you. Okay, I'm suing you. So that's what you do. You countersued back. So hopefully that's helpful. I got a court eviction judgment. Is there any way to get this deleted? Now, it depends on what state you are in. So what you may need to do, find out, because like I said before earlier, I am, with this experience, I am a landlord. So what happens is, if a landlord do a background check, even if action is taken against you, and I warn people all the time, I even try to tell, Lord Jesus, I try to tell my tenants, don't let me put you out. Just try to work something out. That action, if you're playing around and they put that in, it sometimes go into the court system. Even if you don't get locked out, they get, just the action alone can show up. So you need to see if you can call that court and see in your state if it's any way they can delete that action. Find out if it's a time frame for that to go away, or how long that stay in the court system. Because it be, like I said, in New Jersey, where it's New Jersey courts, we can go there. And if that person, many a times, this is why I tell y'all need to know the matrix. People set you up before you get up. The reason why they asking for your information on your address, your prior landlord, their information, because they can look that up. If a lot of times somebody run your name in the system, especially in New Jersey courts, if I just put your name, I can go there myself personally, put your name in the system, and you got your old address down there, and I see, boom, so-and-so eviction file, there's the address, that's you. So you want to make sure you call that court and see if you can get that overturned, and it goes state by state, see if they can take it out, because at that point, it's the court a lot of times that have the filing, not just the collection alone. So I hope that's helpful. So see if you can call the court. How can you teach people to stay in the owner's property? Shaking my head. The owner have a mortgage. Oh, I'm not trying to teach nobody to stay in the owner's property. I think you must have jumped, Michelle, on something else, because I'm talking about removing an eviction collection, and nothing that I said had to do with staying in the owner's property, because I guess, let me repeat it again, I am a landlord. So you won't be staying in mine, because I will get you out. Point blank. So if I know this much, I know how much to get somebody out. So nobody's telling anybody to stay in nobody property, because you're not going to stay in nobody property anyway. All good things come to an end. Let me preach that one. I've been a landlord since I've been the age of 21, and you are not going to stay in somebody property. The subject is here, how to stop eviction collection. This is a third party collection. And what I broke down for the gentleman and the young lady, they're asking, how can I get this off my record, not stay in somebody property? So hopefully I'm being clear, because you won't be staying in somebody property. So, and I don't think nobody in here was thinking on staying in somebody's property for free. because it just don't work like that. It's laws out here that governs that. And as I said at the beginning, it's called landlord tenant laws, and it's called your lease. So if you don't pay your rent, state of New Jersey, state of New Jersey, it's no tolerance, none. You can't stay, non-payment of rent ain't happening. You're getting put out, okay? And there's no way around it. No, ain't no way. That's what Aretha Franklin said. Ain't no way. You're going to get put out. So all these people, even now, if you think you're going to duck and hide, I just said, let me say it again for the people in the back that didn't hear me. If that action is even taken against you, it can stop you from moving forward to getting a place to stay. So no, I don't advocate anybody staying in somebody's property without paying, especially not paying me, because you will pay me. You will pay. You will today. You will learn today. You will pay me. Bankruptcy will stop collections. Samuel, I wouldn't advocate for somebody to file bankruptcy for a small collections. And let me tell you why. I deal with people that have bankruptcies. And I will tell you, only way I say to file a bankruptcy from what my mind can see, if it's to keep a property, but the implications of filing bankruptcy just to try to stay in somebody's house or trying to stop a simple collection. I had people, because they didn't want to pay like $2,000, out here filing bankruptcy, and I don't know who told y'all that, because bankruptcy stay on your credit for 10 years. I'd rather pay somebody with good sense $2,000 than sit up there and file for bankruptcy. I don't know what this information, or maybe it's the industry telling y'all just filing bankruptcy is the best option, because people think they're going to duck their bills. There's many ways that you can fight stuff than filing bankruptcy. Now, I don't care what people tell you. Bankruptcy down the road can stop you from getting state contracts, can stop you from getting certain jobs, just having that there. Because what you don't understand, LexisNexis, these CRAs, these data providers in the background, that stuff don't disappear 7 years. It's there. Okay? So when it comes down to financial jobs, when it comes down to you getting a home, yeah, you know, you can go FHA within 2 years after a bankruptcy. But there's a lot of times with business credit, if you're trying to do that, you're not going to go very far with the bankruptcy, or it can take a very long time. So it depends on your aspirations. But for me personally, I don't care if I owe $50,000, $60,000, $70,000, $100,000. Me, myself, knowing the implications of bankruptcy, I wouldn't do that unless I'm trying to keep some property. But that's just me. I wouldn't do bankruptcy, or unless, I guess, medical bills, I could see how people may, but you got to keep in mind, bankruptcy is not the end-all, be-all for everything. A lot of people have filed bankruptcy that call me, come to me about student loans. You cannot bankrupt off student loans. So a lot of people around here is getting misinformation, tearing their credit down, and people think it's just overnight, I could dispute bankruptcy. No, it takes some time to get some bankruptcy off of your credit. Don't let nobody lie to you. Because number one, you got to dispute the bankruptcy under the public action. Okay, that's number one. It's going to be under 3 credit reports, all 3. It's in the PACER system, the federal system. That's the court system. This is stuff y'all don't see what's working in the background. The federal court system. That information is there, that the action has been filed. And I have seen people that run around here playing these games. They don't get a bankruptcy, file bankruptcy, and then get a discharge and playing the game again to file bankruptcy again, and then file it again, and then wonder why they got 3 bankruptcies on their credit reports, because it's being recorded in the PACER system, in these court systems. So how are you going to dispute that? So Once you get one bankruptcy in the public records, now you got to dispute it through all 3 credit bureaus. Not saying it's going to fall off like right brain in the summertime. That's number 1. You got 3 to get off. Then you got to get off the accounts and dispute those accounts, each account that you file bankruptcy for those accounts to be closed out. Because if you look at your credit report, when you file for bankruptcy, furthermore, each account that got discharged in that bankruptcy will say underneath there, discharge under Chapter 7, Chapter 13, whatever it may be. Then you have to try to dispute each one of those accounts across 3 credit reports. So it's not as easy as people think. So what I will suggest for people to try to avoid bankruptcy if all is possible. So hopefully, I know there's time people trying to keep stuff, but hopefully, if it's just a small collection, you can apply what I just said and just rope-a-dope, duck your way out, shoot your way out of Dodge, whatever you need to do to slither out of it. But bankruptcy, to me, have too many long-standing increments or just consequences. Now, Chapter 13 will only show there for 5 years, but that's a payment plan. No, 7 years, my bad. 7 years, what I'm talking about, 5 years. Usually it's a 5-year plan, but it'll stay on your credit for 7 years. But Chapter 7, which a lot of people do, it will stay on for 10 years. So hopefully this information is helpful, you guys. If it's any more questions, please let me know. Hopefully this, if you have more questions in reference to eviction collections, hopefully you just drop the comments in the video and I can address the questions. And I hope this was informational for you guys. Thank you so much, Miss Smith. Thank you for joining me. Thank you, all of you, for joining me. And I hope the content is helpful for you guys. Subscribe to the channel. I also dropped the video about the upcoming EDIL loan. So a lot of people didn't get that stimulus check as we all hope for $2,000. But you need to be your own stimulus, start a business. I have a business channel. My daughter and I, How to Make Money While You Sleep. She runs most of my social media and all that stuff for me. And also my website. So she's giving content on Bitcoin. She's 24. So she's more tech savvy and with ClickFunnels and how she makes money actually for at home. So I'm happy for her. She's a full-time student, so she made other options of making money. So if y'all have any more questions, feel free to reach out to me. Enjoy your night, everyone, and be safe. God bless.